too important.
Jackie Dean.
I move that the question be now put.
The question is that the question be now put. Those of that opinion will say aye. Contrary, no. Ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
8 votes opposed.
Māori Party. Mana.
1 opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 in favour.
Any other votes?
The ayes are 61, the noes are 57. The ayes have it. Call on government order of the day. Sorry? Oh, sorry. David, I can't use it. Oh, sorry. Yeah. The question is that the motion be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
8 votes opposed.
Māori Party. Mana.
1 opposed.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
Any other votes?
The ayes are 61, the noes are 57. The motion is agreed to. Call on government order of the day number 2.
Interrupted debate on the third reading of the Jury Service and Protection of Particulars of Jury List Information Amendment Bill.
Members, when the House was last debating this matter, Charles Chevelle had the call and he has 9.5 minutes remaining, should he wish to.
Thank you, Mr Speaker. Mr Speaker, when the debate was interrupted on this bill, I was just making the point that really it deals with 3 matters. The first relates to the circumstances in which the personal information, including the addresses of jurors, can be accessed by persons including defence counsel and unrepresented defendants. The second situation with which the bill deals is the position of persons in particular over 65 years of age who want to be excused from jury duty. And what it does is it allows people in that category to get a permanent exemption from the requirement to serve on a jury. And the third thing that the legislation would do is to close a loophole in the Sentencing Act 2007 so as to treat people who are sentenced to home detention essentially on the same basis as those who are sentenced to a custodial sentence as far as entitlement to serve on a jury is concerned. So those are the 3 main things that this legislation does. On the first point around the access to entitlements to juror information, we're told from the Cabinet papers, because as I said last night, there's no regulatory impact statement. This wasn't regarded as significant enough to produce one, this particular bill, that there was a case last year where a self-represented accused corresponded with persons whose names and addresses were on the jury panel for his trial. This raised concern about the safety of jurors, and it was decided to amend the Juries Act to restrict access to jurors' access details. So, sir, under the bill, defence attorneys and advisors to defendants representing themselves will not be permitted to show a juror's address to a defendant. Well, sir, we support that. We can see that there's a case for it. If there was a situation where that was abused, then of course jurors ought to be protected from intimidation in any way that this House can manage it. But as was pointed out in the committee stages, there are some problems with this part of the provision. We really are only seeing partial protections, and we could have seen a much more imaginative approach from the government, particularly in the age of Google and social media, where essentially anybody in the well of the court, as members around the House who've had experience in the courtroom through fair means or foul will know, essentially it's possible to look up a juror's details provided you have their name. You can Google it, you can find it through Facebook, you can look in the telephone book. And so I do wonder whether, as I said in the committee stage contribution that I made, Sir, we're going far enough, or whether we're only providing a partial protection. The other concern that I've got about this provision relates to some evidence that we received in the Justice and Electoral Committee around the effect of the government's proposed cuts to legal aid and legal aid entitlements. And that relates to judges coming along to the Select Committee and telling us that there would be inevitably a massive increase in the number of self-represented defendants coming before New Zealand courts. It's just a fact of life that when you make it more difficult for people to access a lawyer when they're accused of a crime, many are going to turn to the last resort of representing themselves. Now, obviously, what the judges told us is in that case, they are going to need to slow trials down and slow processes down in order to avoid appeals and in order to preserve the actuality and the appearance of fairness in the courts. Judges are going to have to treat self-represented defendants very, very carefully. And so as we see this great increase in self-represented defendants, I think there are going to be two effects as far as juries are concerned. Even when people representing themselves are admonished not to contact jurors personally, the reality is some of them won't understand the admonishment adequately. And so there will be more attempts to Google and to Facebook and to look up in the phone book the names of jurors who, in the mind or the eyes of the self-represented defendant, just haven't done a fair job by that person. And the second effect is going to be that there will be self-represented people who just don't care about the admonishment. They're not bound by the ethical codes that barristers and solicitors are. They're not going to care if they're told by the court not to look up the jurors' details. They will go ahead and do it. And I'm concerned that we haven't put in place a regime which makes it effectively an offence to do that on a much more established and clear basis than is the case now, where really this is just a matter for the contempt powers of the court. That's where I think we're failing in this particular provision, and that's why I have some concerns about it. But on balance, because it does provide better protections than exist at the moment, my colleagues and I will support it with the reservations that I've stated. So the second provision that I mentioned substantively that this legislation will deal with is the amendments that are put in place around the entitlement of persons over 65 to get a permanent excusal from jury service. Now, I understand that the motivation for this is well-intentioned. We heard again in the committee stage that this was designed to show some appreciation and some recognition of older New Zealanders' service, and to say it's cruel to make them continue to apply for excusals on a continuing basis if they're summoned more than once for jury trials. I understand the logic of that, sir, but I don't agree with it. And here's why. It's simply a question of demographics. We're going to have over 1 million New Zealanders over the age of 65 in 20 years' time. We simply can't afford to deny juries their experience on the service in the service of the justice system. And so this is really silly public policy, sir. We oppose that part of the legislation. But finally, the loophole to be closed in the Sentencing Amendment Act so that we do treat people on home detention and people in custodial situations as in the same category as far as preserving the purity and the unbiased nature of the jury pool is concerned. That is probably good public policy, and we do support it. So we have three substantive provisions, sir. One which is bad, one which is good, and one which is frankly a half measure, but it provides better protection than exists at the moment. So on balance, sir, we're supporting the bill, but it is inconsistent with good public policy generally. It will create greater problems as we see the move to more represented defendants. And, sir, it's oddly prioritised. The legislative history of the bill shows that this has been on the order paper since 5 April 2001. It's only now that we are progressing it. And with this sort of leisurely timetable, 2011, I beg your pardon, sir, but that's bad enough, 5 April 2011 till the 13th of September 2012. If we were serious about the sort of measures that are contained in this legislation, if the government were serious about providing better protections to jurors and about its law and order agenda generally, then we would have seen, first of all, a much better thought-out series of measures, sir, but secondly, also a much better legislative progress for this sort of measure, because it is the sort of thing that ought not to languish as long as it has.
Jackie Dean.
Thank you, Mr. Speaker. The jury service and protection of